Thank you, Your Honor. My name is William Rose, and with me is Peter Ely, and we represent the plaintiff in this case, Lynn Ann Coombes, the administratrix of the estate of Kevin Coombes. Kevin died when he was 10 years old as a result of a pedestrian motor vehicle accident, and Lynn Ann Coombes was his mother. The accident involved a vehicle driven by a David Saka, who was 75 years old at the time, and he was dying of terminal cancer. He was being treated by Dr. Roland Florio, his primary care physician, who was also prescribing medications for him. At the time of the accident, it was about 3 to 3:15 on a Friday afternoon. Mr. Saka was driving down Sumner Street in Stoughton. He felt pain in his chest and in his left shoulder. He blacked out, went off the road, went up on the sidewalk, across a lawn, went across Brick Hill Road.
Is the evidence such, or the record such, that you can attribute the what caused him to have the blackout? Was it due to medication?
Well,
or due to his general debilitated physical state? Because he had a lot of things wrong with him, I know.
correct.
What was it due to? Was the record established that combination of both?
Well, our expert, Dr. Levine, indicates that it was his physical condition, his medical, the medications prescribed by Dr. Florio, and/or a combination of both. There were at least two of the medications carried with him warnings about driving, and he had severely debilitating pulmonary and cardiac issues.
So how many medications was he on?
7 or 8.
Mr. Rose, is your position that the doctor had a duty of care to the general public? That is, to warn his patient about the side effects and the dangers of all the drugs, to protect everyone in the general public?
No, Your Honor. Our position, just like in the social host liability cases or dram shop liability cases, is that when there is a risk that you're putting an impaired driver on the road, or at least you have some involvement in that impairment, including counseling the patient, which was his obligation as a primary care doctor, and prescribing medications that carry these warnings that could affect driving, that he has that obligation to the people who are exposed by that risk.
That's the world, isn't it?
Not necessarily, but it's no different than in the GW case. They talk about the exposure in Irwin versus Ware, and they said it didn't matter if the motorist went off the road and hit a bicyclist or drove into somebody's house and hit somebody sitting in their living room. The negligence of the defendant is the same. And
but the duty, I mean, we're talking about the bartender case, the serving someone of excessive amounts of alcohol.
I was actually talking about Irwin versus Ware, the police officer.
The police officer who stopped a drunk driver,
correct,
clearly drunk driver, and
right,
let him go.
Right.
And then he had an accident within, minutes thereafter.
Correct.
Okay, so he literally had custody of someone who was impaired at that moment in time,
Mm-hmm.
and let him go, the risk of an accident occurring being very great.
Mm-hmm. Right.
How does that relate to this? We have Mr. Saka never had a driving problem, never blacked out, never had any driving issues at all, hadn't seen the doctor for 3 months, was driving almost every day, as I can tell the record, without any difficulty. Then he has some sort of blackout. He gets dizzy, shortness of breath. I mean, isn't that very different?
I would dispute the fact that he had no problems driving.
Well, what does the record say about that?
That he did not drive from July 2000 until October of 2001.
Because he was having chemotherapy.
No, he had chemotherapy only in November of 2000. He had radiation from February to April of 2001. He did not drive from July 2000 until the end of October 2001 at Dr. Florio's instructions.
Mr. Lowe's, can I just ask you this? Is it clear that the doctor said nothing to this patient about driving?
That's his testimony. His testimony was he talked about general activities.
Whose testimony?
Dr. Florio's, I'm
sorry.
Well,
did the expert opine that this is a likely result from the patient's condition, that this blackout is or seizure or whatever he had is a likely result from the condition?
He did. He said it was to a reasonable degree of medical certainty.
Is that in the record?
Yes, it's at page 85. There's two letters from the Dr. Levine, page 85 and at page 411.
Mr. Rose, am I correct that other courts are split on whether or not this duty exists in these circumstances?
I believe that's true, but there are reasons for that, I would think. Some of them, I consider this a duty to warn case. So just like any other duty to warn case, if the risk is known to the patient, then there's no duty to provide a warning of something that they already know. There's some cases where the patient was a registered nurse, and she had a habit of falling asleep during the day, even when she was driving. And the court said, well, she had as much knowledge of that as the doctor. There was no duty to warn.
So, let's see if
Therefore,
I
there's
got this right. Someone like this man, what is he, 75 or something?
Correct.
Goes to the doctor, and he's on 7 or 8 medications, some of which were prescribed by the doctor. The doctor is supposed to acquaint himself or herself with everything that's in the literature about, which the drug companies supply, about what can happen when you take these things, including when they interact with each other, and then say to the patient, here are all the risks of taking this stuff, and you shouldn't drive. Is that about the size of it?
Except for two things. One is he was the only one prescribing these medications. There were no prescriptions by any of the doctors other than Dr. Florio at the time.
So they all came from Dr. Florio.
That's correct. And secondly, the Coombes case specifically says that that is the primary care doctor's responsibility. It's not the pharmacist's. It's not the internists. It's not...
Right.
the
It's
drug-
responsibility to the patient.
Correct.
Did you say there was no duty to warn?
There's no duty to warn in circumstances
Oh.
where the patient already knows the risk. If there's another case where
So what's the duty here?
the duty is when the doctor has that knowledge and doesn't pass it along to the patient, either as to his conditions or his medication.
So this doctor didn't warn him at all.
That's correct.
He just says, keep taking your stuff, and hopefully you'll pull out of this.
According to his testimony, if you believe Julie Tucker's testimony, who was Mr. Saka's adult daughter who went to all these treatments, she said that Dr. Florio said, don't drive from July of 2000 till October of 2001, and then...
When he was under treatment for chemo and radiation and...
Again, no, he was not. He had the chemotherapy November of 2000, radiation February to April of 2001. So the instruction to not drive continued from April of 2001 until the end of October 2001.
Was that, you mean he instructed him every month or something, or?
No,
or,
it's just apparently as a continuous instruction.
And
Can-
why?
but
was
I
it some-
take it.
what
Let
was
me
her
get to the.
ex-
Can I get to the fact issue on this, please, for a second?
Sure.
So in October, what happened in October? The results came back showing that his situation was stabilized.
Now just the opposite. A CT scan was done in August of 2001, which said he had originally tumors in his a tumor in his right lung and lymph node cancer. That was the original diagnosis. He went through the radiation. The right lung tumor went from 3.8 centimeters to 2.2. They did a CT scan that made that determination. Unfortunately, the CT scan also established he had 2 new tumors in his left lung.
So why did the doctor, what prompted the doctor to change the direction? Was there a change in medication, a significant change in medication?
No.
Mr. Rose, may I ask you this? The daughter testified that the doctor had said, don't drive for a specific period of time, correct?
She said, she didn't explain why she said he said not to do it because he couldn't breathe. But beyond that, I'm not sure why.
But for a specific period of time, don't drive from this date until that date.
I don't think the instruction was that. I think that's just the way it worked out. But
Always lurking in these cases, and this is a big elephant in this room, is the economic consequences of a decision in your favor. Matter of fact, we've got some amicus briefs, as I recall, that raise the issue directly. Clearly, if we impose malpractice obligations on doctors in this situation, rates will go up. We're already suffering a terrible shortage of doctors in Massachusetts because of, allegedly, among other things, malpractice rates. Issue, not an issue, forget about it, don't worry about it, let the chips fall where they may.
well, it's an issue because it's raised and it's been argued, and it seems to.
But it's not quantified. I mean, there's no
no
actuarial evidence saying, okay, here's what's going to happen. Most doctors, I imagine, will step up to the plate and exercise on the side of caution, tell anybody where there's the remotest possibility they could have a spell, don't you dare drive.
Right, and
But is that an appropriate consideration for this court anyway? Isn't that something for the legislature to consider?
I believe it is, as the court indicated in the Jocelyn case, and Another issue about
Wait a
that.
minute. Does it make a difference that the patient had been taking these medications for several months before the accident happened? I mean, this isn't a situation where he walked out of the doctor's office and the doctor had just given him some medication and failed to say don't drive. He had been, I take it, been feeling woozy for several months as a result of these medications.
That's true, and because of his conditions. But our position is that his condition was worsening. Dr. Florio knew that the cancer was metastasizing. He admitted that based on the finding in the CAT scan of August of 2001. There was no active treatments to reduce it, so it was clear the cancer was going to be further
Of course, all
debilitating.
you're looking for today is to get by summary judgment.
That's correct.
So an awful lot of these questions that we're talking about will be sorted out later. It's just that, you need the creation of a duty, I guess you call it a duty to warn, to get by the summary judgment stage.
And the duty is already owed to the patient. And why? Because it's a foreseeable motor vehicle accident.
Yes, but let me just see if I'm understanding you. I know you said the doctor testified that it was reasonably foreseeable that the plaintiff would black out or have a seizure as a result of the medications or as a result of the medications and his condition.
Correct.
Correct. Which one is correct? The latter one?
I believe so, yes. And like I said, his conditions were known to be debilitating and becoming more so. That's the testimony. He, in fact, died 4 months later from cardiac arrest.
So, in fact, he might have been able to drive the day he came out of the doctor's office and for a little bit forward, but at some point he became unable to drive, possibly.
That's correct.
But
Now,
let me
clearly-
understand the record, though. He was driving. You say he resumed driving in October.
That's correct.
What does the record say about October to the end of March?
It doesn't really say specifically how often he drove.
But he did drive.
He did.
There's certainly evidence that he drove. His
That's correct.
daughter testified. In fact, he'd been to the store the day before. And were there any problems with his driving during that period of time?
Not that we're aware of.
Right. Or even before he started his chemotherapy?
In terms of driving, no, but in terms of his breathing, absolutely. He had respiratory failure, in 2000. He had...
I understand that, but I'm talking about he's been on these medications for a long period of time.
Correct.
Under a doctor's care since 1984,
Correct.
for a whole variety of conditions, lung
Well-
cancer just being one of many.
The 1984 was colon cancer, which, obviously is not something
I
we're
take
talking about
it,
here.
Mr. Lowes, that it wasn't just that he resumed driving in October, but that Dr. Florio authorized him or said he could resume driving,
That's correct. He did not drive when Dr. Florio told him not to, and then
So-
Dr. Florio said okay, and so he drove again.
So your position is either at that stage he shouldn't have done that, or somewhere between October and March, as the doctor saw or knew about his patient deteriorating, did he?
Yes, he did. He testified that he knew the cancer was metastasizing. He knew that would affect his general health and virtually every bodily system that he had, cardiac, pulmonary, everything else.
So your position is even if Dr. Florio in October made a medical judgment that it was safe for his patient to drive, that at some point between October and March it became unsafe. The doctor knew about that, and the doctor should have warned his patient again, which is what I understand he did previously.
No, he said, you're okay to drive now and you're fine, go ahead.
Previously, he had told his patient not to drive, correct?
That's what Julie Tucker's testimony was. right.
October, he says, as I understand it, the evidence, at least for summary judgment purposes, is Dr. Florio authorizes his patient to drive again.
And said, you're fine, you can
And
drive
said you're
again.
fine. So it's not as if driving and the linkage to the harms caused, the potential risk, the potential harms was unknown to this doctor. And your claim is that somewhere between October and March, there was a tipping point, and this doctor should have warned his patient again, stop driving.
That's correct.
Okay. Do
And
you,
that he- and that
do
he
you
should
pick
have-
a time between October and March?
Well, that's difficult for us because there's no medical records because he didn't see him after January 4th. So he didn't see him for 2.5 months, even though, again, he knew his condition was debilitating. And
Is it
getting
clear, is your expert opinion opining that as of January, at least as of January, to a reasonable degree of medical certainty, blackouts could be anticipated?
He didn't specify a date, but he said based on the evidence that he should have had that information and had that information, prior to the loss. And he should have.
So your argument really is that the doctor should have seen him more often, should have monitored his situation more carefully.
Yes, he should have.
And that was a duty he owed to the general public, not just to his patient.
And for the purpose of telling the patient about his driving abilities, which necessarily foresees an accident, which...
Well, what else should the doctor have warned him about? He has, I think he has a grandson, right?
Correct. Or granddaughter.
Well, I mean, should he have warned him, geez, don't pick up small children? Because, you can get dizzy and fall? I mean, what are the extent of obligations that the doctor owes to the general public here?
Well, our position, Your Honor, is that a lot of this is already established as to the patient. We're only asking that the duty to the patient be extended to the foreseeable plaintiffs who are exposed by that breach by the
Yes, but
doctor.
Justice Cordy is asking you if that would include, say, the patient's grandson, and include a general warning to curtail your everyday activities, because there's a danger both to you and to other people.
The answer has got to be yes.
Absolutely, and that's what Dr. Florio testified to.
There was some mention in the briefs that, at least with respect to other patients, the doctor had, I think, notified the Registry of Motor Vehicles.
No, the law in Massachusetts is it's the patient's obligation to report, which again is within the confidentiality provisions that doctors need to be concerned about. So what he said was, I would tell the patient that you should initiate that process, and then I will do the paperwork. And he did that for seizure patients, cardiac patients, pulmonary patients, and orthopedic patients. Other than seizures, Mr. Saka had all three. And also, Dr. Florio testified he would provide alternative transportation for his patients who were at risk, so they would not drive. He didn't do that with Mr. Saka.
Alternative transportation for their life, or just to get back and forth to the doctor's office?
No, he would give them vouchers to go on public transportation for buses around the Brockton area.
God, pretty good doctor.
Yeah. But he didn't. His testimony was he gave advice and counseling about general activities, doesn't have any memory whatsoever about driving until after the accident, and then everybody said, you should never drive again, and that's what the emergency room doctor said, that's what Dr. Florio said, and he never drove again until he died 4 months later.
Thank you, Mr. Lewis.
Thank you.
Mr. Mahoney?
Thank you, Your Honor. My name is Ted Mahoney. I represent Dr. Florio. Finding a duty on the part of Dr. Florio in this case under these facts would be an extraordinary expansion of the duty owed by physicians.
It would be helpful to me, Mr. Mahoney, if you could focus on what, if anything, should have occurred on Dr. Florio's last visit with his patient, which I think is January. I mean, that's only I know that from Mr. Lowe's. In other words, correct me if I'm wrong, at some point prior to October, Dr. Florio had told this patient, don't drive. Is that correct?
Dr. Florio, unfortunately, has no memory, Your Honor, but that is the testimony of Ms. Tucker, yes.
So at least for purposes of, well, I mean, that may be a disputed issue of fact, but that would make some difference. But let's assume, taking those facts, then again, according to the daughter, in October, Dr. Florio authorized him to drive again?
That's what she says.
Okay. And then in January, when he saw, if January is the last visit, there was no discussion about driving, correct?
That's what she says.
Okay. And he doesn't say otherwise about January, correct?
He does not.
Okay. Why should that not be the basis of concluding that there was a duty to warn this patient about the risk of harm that he could cause to others? If, in fact, you've got expert testimony, I'm assuming that there will be expert testimony. The jury could decide if it's valid.
Well, first of all, I don't think the expert testimony in this case does address that. Justice Cordy asked a question about whether there was a criticism of a failure to warn at any specific time, and there was not. But the duty, let's assume Ms. Tucker is right, and Dr. Florio did advise his patient not to drive. That's a duty he owes to his patient, and that was a recommendation he made to his patient at that time.
I understand, but unlike the other risks, such as don't lift up a grandchild, which might have risk to the grandchild as well, but be careful walking down steps or something. One reason why you say don't drive is because I don't want you to be involved in an accident, but I also don't want you to kill or damage or injure anybody else, correct? I mean, he can't be warning his patient to protect his patient only.
Well, in his deposition, a lengthy deposition, he was asked questions about...
Who's the he, sorry?
I'm sorry, Dr. Florio.
Okay.
There was no testimony at all from Dr. Florio or anyone, and there's nothing in the record about whether indeed in giving that warning he is considering the general public. I agree, Your Honor, that logic would indicate that if there's an accident, it might involve more than one person. Sure. But when Dr. Florio was questioned, he was questioned about driving and instructions and so forth with respect to his patient. One other thing about that January 4 visit, because I think it's a very important visit, is that if you look at the record, and it's at page 200 of the appendix, there's a chart for that particular visit that checks off certain symptoms that are being reported by the patient. And in that visit, the chart, and this is the same chart that's been utilized by Dr. Florio in many other visits. And as a matter of fact, in this visit, there are far fewer symptoms that are checked off by Dr. Florio. For example, in the chart for malaise is not checked off, dizziness not checked off, syncope not checked off, seizures, weakness, depression. If you look at the chart on January 4 of the record, it actually is far better than it is. Now, we know that Mr. Sacca had cancer, obviously, which progresses over time, but in terms of how he was doing at that time, the record in this case, in comparison with times earlier, is significantly better.
Mr. Mahoney, assuming, it seems to me that we can make one of two decisions. We can either say there is no duty to warn third parties. I mean, there is no duty that runs to third parties. That's one way to do it. And so then you decide you're out on, the case is out on summary judgment. The second way is to say there may be facts in a particular case where there is a duty, and we can't resolve those facts because there are disputed issues as to whether or not it was appropriate at the January visit, which was the last visit, to give this warning. You're suggesting that it probably wasn't necessary in January for Dr. Florio to give the warning because of the record that you've just run through.
Well, I think I'm saying a little bit more than that, Your Honor. I agree with you that one way for the court to affirm what the lower court did was to say that in general there is no duty on the part of a physician to members of the general public. As Judge Donovan said, are you saying he owes a duty to the world? But I think on the second issue that Your Honor raises, I don't think there's a question of fact that would make it appropriate to go back to the lower court in this case, because I think as a matter of law in this case, this particular accident that occurred 2.5 months after he last saw him on a patient who had never had any driving problems whatsoever, had never blacked out, that this particular accident was unforeseeable, as that term is used by this court in establishing a duty. And if we look at just what the evidence in this case is that's been touched on before, there's no evidence in this case at all that he had ever had a problem with his license, ever had a traffic citation, ever had an accident, ever blacked out. There's nothing to suggest that.
Well, that again, I think that begs the question, because it might be that you're looking at the foreseeable risk. Once you get past the, assuming that you have a duty to members of the general public, it may be that in a particular case, somebody doesn't black out, or maybe they blacked out when they weren't driving a car. The question is it foreseeable?
Right, and I think that in the cases where the court has established a duty on the part of an individual to others, so the duty through a third person to others, if one were to look at those cases, typically the duty is confined to either a time limitation or a geographic limitation, some limitation on the duty that's owed. For example, if we were to look at all of the dram shop cases, they involve intoxication, or Irwin versus Ware. They involve intoxication. The intoxicated motorist is not going to be intoxicated some hours after. That duty is limited to the number of hours that the patient...
Yeah, in these cases with doctors also involve a lot of judgment calls, which, isn't really true with people that are drunk. necessarily.
Sorry.
Should we consider the economic consequences of this?
I think you
Is this
have-
being defended on the basis of this malpractice on the doctor's part?
Yes, it is. It's being...
Under reservation of rights?
Not that I know of, Your Honor. I can't say for that with certain, but if it is, I'm not aware of it.
Well, put it this way, if there's a duty to members of the general public, there's certainly a duty to the patient, correct?
I would think that it would,
Yeah, so-
you certainly would have that, yes.
Is this, well, one way to approach this, I don't know if this has ever been done, but if we decide there is such a duty, could it be made prospective so that doctors would have, and not apply it to this case?
Well, I think then that I agree with Your Honor that this would have a tremendous impact. And if we were to look at what the legislature has done in the laws that it's enacted with respect to medical malpractice, while the legislature has maintained the ability of a patient to sue a physician, it has put in many limitations.
Oh,
that
sure,
apply
malpractice tribunals and
sure, malpractice
all
tribunals,
kinds of stuff, caps.
That's right.
Occasionally, so on.
And even beyond that, Your Honor, in terms of the laws with respect to mental health professionals, where a patient makes a threat to someone and then carries that out, the legislature enacted a statute where the general rule is that mental health professionals do not have a duty to warn members of the general public
This
unless...
doctor seemed to have a better sense than perhaps many others do, that something can go wrong with this kind of stuff, because we heard he, told people who shouldn't drive, they got to fill out the form, send it down to the registry, gave them vouchers to take buses around town, all that kind of stuff.
And good for him.
Yeah, I
Mr.
said good for him.
Yeah.
Mr. Mahoney, let me ask you this. First of all, we don't have a statute. It's the common law we're dealing with here. I know that Mr. Rose referred to the restatement second. As you probably know, the American Law Institute is considerably revising just this area of law in the restatement third. And I wondered whether you'd had a look at what the recommendations of the ALI are. I asked the question because Tarasov was obviously the lead case that first established a duty to third parties in a medical context, albeit in a mental health one, which our legislature has now overruled. But my general understanding is that courts around the country have cut back to some extent on the duty to members of the general public on behalf of the medical profession, and I wondered whether you had looked at the restatement third.
I wish I had. I have not, Your Honor, so I can't be...
You can look after the fact.
Yeah.
and
I mean,
let us know.
I don't know. I thank you for looking at the restatement second, but I think that there has been there's a development in the law, and I just don't know where they come down.
Did this go through a malpractice tribunal?
Yeah, it did, Your Honor, and it did not get past the medical malpractice tribunal. A bond was posted, and that was mentioned by some of you in questioning Mr. Rose, but I don't see and this was raised with the lower court, I don't see the plaintiff's expert as establishing, based upon the letters that have been written and are a part of the record, as establishing a liability on Dr. Florio.
Oh, no, I don't think so either. He's just saying that these medications could cause a problem. He's not talking about any duty that's owed.
No, I'm sorry, not in terms of a duty, but that's exactly what he's saying, is that these medications could. And he uses that word could. I don't think he says in his...
Would.
He certainly doesn't say likely. He does not say that. And I don't think either that he says that, in his opinion, that it was the standard of care required Dr. Florio under these circumstances to advise Mr. Saka not to drive. He says... I'm sorry.
If we decide
I was
this
about
case,
to, I was about to ask the question. You heard the woman's voice, and I was about to ask the question, I think. And let me just ask you this. Is it possible in this case, from your point of view, to say that, as I raise the two things, that one could look at the facts in this case and to say whether or not the court ultimately decided that there was a duty to members of the general public in this case, even assuming there is such a duty, which we needn't breach, the facts don't establish any breach of that duty? That's what, when you said to me,
Yes, I think that could be a finding, and I think also as a matter of law, under these facts, there is no duty.
No, I understand that, but it's saying that, but we, as I understood your answer to me, we could get to the legal answer without necessarily, in other words, if we decide I asked you whether you could either prevail on summary judgment if we found no duty or it goes to the jury, and you're saying no as a matter of law. Even if there is a duty, you still win as a matter of law on this record on summary judgment.
Yes.
Yeah, what you're saying is that we could decide this on what was before the malpractice tribunal, which doesn't get into these real broad questions, because they could have well said his expert witness isn't adequate enough to get this where it ought to go.
That's true, and that was an argument that was raised before the lower court. So I think there are three ways to affirm it. One is to say there's no duty on the part of a doctor in general to a member of the general public. That, two, if you don't want to be that broad, the facts of this case, as a matter of law, do not establish a duty on the part of Dr. Florio. He hadn't seen the patient in months. The patient had been driving for or had been taking these medications for more than 2 years in some cases, or three, and therefore it's not foreseeable as a matter of law, or three, not even addressing either of those issues. On this record, the plaintiff's expert has not set out a case against Dr. Florio that would survive a directed verdict. So the tribunal standard do not get past the tribunal.
If we decided this case, if we established the duty that the plaintiffs are seeking in this case, wouldn't we have doctors advising an awful lot of people not to drive?
There's absolutely no
It
question.
might solve the traffic problems.
Maybe that would help us.
And no one would be driving, Your Honor. I mean, we talk
Because there are
about...
so many people on medication for antidepressant and all things like that, which can cause people to be woozy or...
Right. There's no, everybody is at risk of having some event when you drive, and the question is, and a lot of people are on medications.
Well,
and we
put
talk
it this
about,
way, if I'm on medications, I may not know that there's a risk of wooziness, or it's not uncommon to say, take the medication but don't drive within 2 or 3 hours after that. And it seems to me that we would want to be promoting that, not discouraging it, because of the terrible consequences.
We may very well, Your Honor, but this isn't the 2 or 3 hours of the first time you take it.
No, I
This
understand.
is 2 years. But in answer to Justice Cowan's question, I believe that we all hear about defensive medicine with respect to medical malpractice as it is today. The easy answer will be, if there's a duty here on these facts, the easy answer is going to be, you're taking this, you're doing that, you've got this malady, don't drive, don't lift up your grandchildren, don't do anything, and then maybe the warning then becomes meaningless. But I think in this case, if there is a duty, it is a very significant change in what the law is.
Can I ask you one other question? When we look at deciding whether a duty exists in circumstances like this, we obviously look to foreseeability, but we also look to the burdens that it would place on the person whom we're saying now has a duty. What is the additional burden here, as Judge Gantz described in, is it the Medina case?
Yes.
Said that there is no additional burden because the doctor owes the same duty to the patient. So if the doctor owes that duty to the patient, then what's the additional burden, saying that it's also owed to the broader public who might be injured by the patient?
Respectfully, I think the premise of Judge Gantz is incorrect. I don't think it's the same burden, because when physicians treat patients, they consider, in many respects, and on many issues, what is the benefit to this patient of my advice, and what is the detriment to my advice. And with respect to this single issue of driving, obviously a patient under certain circumstances, there can be a great benefit to being able to allow to drive, and there can be a detriment to that patient of possibly getting in an accident. That's what the doctor considers. If you now have a duty beyond this patient, and you have a duty to everyone anywhere, all of a sudden, what is the benefit to the general public of having this particular patient drive? There is none. And so if you now have to consider the fact that I'm making a
different cost-benefit analysis.
It's a different cost-benefit analysis. And now you're saddling doctors in which is already a complex relationship they have with a patient, of having to consider everybody else. Anybody in Massachusetts, someone in New York. If he had a duty to Mr. Sacca, if Mr. Sacca went to New York and drove, what would be the problem with someone coming back into Massachusetts from New York and suing a Massachusetts doctor here? The duty would be tremendous. And I think that would impact the judgments that get made by physicians. So I think the premise is wrong.
Thank you.
Thank you, Mr. Mahoney.
Thank you.